What are the challenges compiling appeal evidence? Imagine trying to put together a puzzle with missing pieces. That's what compiling appeal evidence can feel like in the criminal justice system. When someone files an appeal, they are asking a higher court to review the original trial for legal mistakes. But the evidence used in that appeal is usually limited to what was presented during the trial and the official court record. New evidence is rarely allowed unless it meets very strict rules. One big challenge is getting all the documents from the original trial. This includes transcripts of what was said in court, copies of exhibits, and any motions or orders filed by the judge. Sometimes court staff are slow or parts of the file are missing. If the lawyer didn't keep good records or if they are no longer around, it can be hard to find important pieces like defense exhibits. Transcripts are especially important because they show what happened during the trial. But they can take months to prepare. If the transcripts are missing or incomplete, it becomes difficult to identify errors or mistakes made during the trial. This delay can push back the entire appeal process, making the defendant wait longer for a decision. Legal errors are the main focus of appeals. These can include incorrect rulings on evidence, improper jury instructions, or ineffective assistance from trial lawyers. But to raise these issues, they must be clearly documented in the trial record. If a lawyer didn't object to a mistake at trial, that error might be waived and cannot be used in the appeal. That's why it's so important for defense attorneys to be vigilant during the trial and to make sure potential appeal issues are properly preserved. Introducing new evidence in an appeal is very difficult. Courts usually won't consider evidence that was not presented during the original trial. There are some exceptions, like if new evidence was discovered after the trial that could not have been found earlier with reasonable effort. Even then, the standards are strict, and the evidence must meet specific legal criteria. For defense attorneys, reviewing the trial record quickly after a conviction is key. They need to look for errors that could be grounds for an appeal and request all transcripts and exhibits early. Working closely with trial counsel can help fill gaps in the record. If new evidence appears, attorneys must carefully evaluate whether it qualifies for consideration and prepare strong arguments to include it. When it comes to appeal evidence, courts focus on whether the evidence supports the conviction or shows a legal mistake. They do not reweigh the facts but check if a reasonable jury could have found guilt based on the record. To raise an issue on appeal, the defense must have objected at trial or otherwise pointed out the error. If not, that issue is usually lost. Claims of ineffective assistance of counsel often need outside evidence like affidavits or testimony about what the lawyer did or did not do. In summary, putting together appeal evidence involves overcoming delays in getting court records, making sure errors are properly preserved, and following strict rules about what can be considered. These challenges requiring careful planning, attention to detail, and a good understanding of appellate rules. Success often depends on catching potential issues during trial and acting quickly afterward to secure and review the record.